Harbor Manor versus Catherine Perryman. Recall.
Thank you, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff. Thank you for your patience.
Sometimes it's all I've got. All right, go ahead.
You have a lot of it.
All right, Ms. Redmond.
Good morning again, Your Honor. My name is Gianna Redmond, representing defendant Catherine Perryman, who is in attendance today. I'm requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Allison Friedman.
All right, and you have a partner, I'm presuming, who is also unmuted, so she can go ahead.
Thank you, Your Honor. Good morning. My name is Alexandra McDevitt, also representing Catherine Perryman. I am requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Allison Friedman.
All right, you guys have been before me before, is that correct?
Yes.
Yeah, we're regulars.
Oh, listen, they also become regulars. I like that. They appeared once and now they're a regular. All right. What are we doing on this case?
Your Honor, after last week's hearing, we were able to come to the conclusion that the off-ledger repayment plan is a standard practice and that the ideal outcome would be to re-enter into a payment plan. And we were able to discuss that with our client, Ms. Perryman, and review both the HUD handbook and the documentation around the rent recertification and repayment plan. Ms. Perryman would like to re-enter into a repayment plan to account for that 2020 pandemic unemployment assistance she received from April to December 2020. But unfortunately, the current repayment plan is based on a miscalculated annual income, which was done by Veronica Cottingham, the property manager. So we would just ask that we would enter into a repayment plan for the correct amount. And we're happy to provide clear documentation that shows the miscalculation and brief our explanation and corrected calculations for Your Honor to review. Again, Ms. Perryman does want to repay the landlord, but just for what she owes and nothing more.
Your Honor, if I could.
Isn't that what I said last week?
Yes.
Go ahead. I'm sorry.
Yes, it is. That's what you said. Your Honor, I'd like to respond briefly.
Hold on one moment, Mr. Hughes. Somebody has entered in here and refuses to mute themselves. All right, we've done it for him. Go ahead, Mr. Hughes.
We do have a signed repayment agreement where the parties acknowledge the amount that's due. Secondly, their characterization that Veronica Cottingham was the one that did the recertification is incorrect. It was their superiors that do the compliance work, and they are wrong in their assessment, indicating that it was in fact miscalculated. Calculation for unemployment is on a 12-month basis per HUD 4.350.3. We can sort that out through a motion. What's most troubling here is that this defendant has received SARA funding well in excess of what she is paid to the landlord. I have asked them to produce for me the amount of money that she still has in hand, and they played coy and said, well, we don't have a bank account, it's not there, so we're not telling you what it is.
Your Honor.
Let me just see if, hold on before you go on. Let me just see if I can sort this out. There, as I'm recalling, there's the back rent issue, and then there is the repayment issue, and it got tacked onto the ledger, as I'm recalling. And then there was the issue of what was really due. If I take what I'm hearing you say to me, Mr. Hughes, is that the funds that were received from Sarah are in excess of what's due.
On the ledger, that's correct. It would be to her benefit if those funds were paid towards the reconciled repayment plan, because it would reduce the amount of money that is owed her. I suspect.
No, I get that, but what I'm trying to get at is the accusation that you're making is that she received Sarah funds and has not paid those funds over to the landlord. What I'm trying to figure out,
funds, not all of the funds.
Right. What I'm trying to figure out is she didn't, after you take the repayment off, whatever that number is, she did not pay that in full with the Sarah funds. Is that what I'm hearing?
That's correct.
Okay. So yes, you may respond.
Okay, thank you. Okay, I will go ahead and respond. Your Honor, we see this as two different issues, the repayment plan being one for the 2020 pandemic unemployment assistance. And that was left off of the Sarah application because it's our understanding, based on conversations with both Mr. Huth and the Sarah program, that the Sarah funds could not be used for that. And if that's no longer the case, then we would return to our argument that it should have been included in the original Sarah application and conditional dismissal. And if that's true, then it would have been waived for being excluded. But
Waived, what would be waived?
the balance of the repayment plan. If Mr. Huth is saying that the funds can now be used for the repayment plan, then we would argue that it should have been included in the original.
Well, hold it, folks. You guys are making something that seems to me rather straightforward and simple, a lot more complicated than it needs to be. My understanding is that Sarah would not pay that.
Exactly.
Okay. So that has to come off, which is where we started off at the very beginning, that there may need to be a new repayment plan adjusted or whatever.
That's correct.
The issue now that I see, and I don't see it necessarily as two issues, but I guess you can look at it that way, is that after you take those funds off, then she still has a balance.
Yes, Your Honor, we agree that Ms. Perryman does owe for the pandemic unemployment assistance that she received in 2020 for 39 months. And again, we are happy to brief and explain our calculations based on HUD Handbook Rule 5-5.
This is why you should have gone to the University of Maryland. You don't have to brief everything. I just need an explanation. Everybody from Michigan wants to brief something.
I can give an explanation if you prefer that.
No, whatever you guys want to do. I'm just saying this. This to me is just math.
Yes.
All right. Because, yeah, we can get down into the argument of the calculation. But at some point, both parties, it seems to me, agree that after I take that repayment thing, the repayment plan off, that and the credit the defendant the payment that she made of the Sarah funds, there is still a balance. The extent of that balance may be just in dispute, right?
That's correct.
Okay. So I guess my question is, the first issue is, if there were enough funds from Sarah to zero her account after you take that off, where's that money? Even if what's paid is what you've calculated at this point.
That's the question, Judge, that I've asked and they refuse to answer.
If I can.
Well, I asked much nicer, so maybe they'll answer me.
Thank you.
Your Honor, Ms. Perryman, we do recognize that there is a difference in the amount of funds that Ms. Perryman received from the Sarah program, which was earmarked for rent, and what she paid in rent. We are currently in the process of addressing this discrepancy with the Sarah administrators and SOS Community Services. They're aware of this, and we're working to come to a resolution regarding these funds with them right now. It's our belief.
Hold it. I know. I look like, and I am. I'm just a little country judge trying to do a little bit of justice. That's all I do every day. She got a certain amount of money, right?
Yes.
That money did not get paid to the landlord.
Yep. So Ms. Perryman.
So regardless of any discrepancy with the Sarah program that may result in more money, the money she got, she didn't pay.
Yes, so Miss Perryman,
So where's the money?
so she received the Sarah funds, paid down her rent balance to zero, which was for $2,848. She was then never informed by the landlord, nor was she represented at that time. So she assumed that the remaining funds were lumped in with what she received for her utilities and internet bills.
Hold on, whoa. Stop. I'm going to stop you.
Okay.
I thought we were all in agreement that after I take that repayment off, then there's a certain dollar amount left. And then she had enough Sarah funds to bring that to zero. Now, you just mentioned that in what you said to me, that she brought something to zero, but I thought we were in agreement before that she had not brought it to zero.
Your
Judge,
Honor, her ledger is zero right now.
Maybe I can help, Judge. Look at it two different ways. There's a ledger account balance for non-payment of rent, and there's another repayment plan balance. She received Sarah funding that would probably cover both of those accounts. She only took part of the money that she received from Sarah and paid off her ledger balance. We have yet to hear from Ms. McDivitt what amount of money was left over from the Sarah payment that Ms. Perryman received that was not used to pay rent. It would appear to
Okay,
me
but
that
hold on. Okay, because that's not what I was hearing at first. If her rent ledger got paid to zero,
correct. Everybody agrees to that.
then, okay, so good. Now we're all in agreement on that. Then, Mr. Hughes, I guess I have to ask you, why are you concerned about this extra money? Because that extra money would be between Sarah, which really was an overpayment based upon something that Sarah won't pay for, and the defendant.
As you are a country judge, I'm a country lawyer, and looking at this very practically, it would serve the tenant's benefit if the Sarah money was used to pay that arrearage. Now, if not,
and it would serve the tenant's benefit if there were leprechauns and pots of gold. However, the thing is that you don't get that money because Sarah says, I can't pay it. They can't pay that repayment plan.
So then what happens to that money?
I don't know.
Your Honor, if I can jump in here, that's why we're in discussions with Sarah currently. They are aware of this discrepancy. And we have had conversations yesterday with Sarah Lee and both Emily from SOS Community Services about coming to the resolution about paying the money back through a repayment plan.
That's it. The reality is she has to pay that money back to Sarah. But that's not between her and the landlord.
Right. And that's what we have. That's why I was saying that we think it's two separate issues.
I know, but you were saying it like the University of Michigan way, which was taking a really long time, and I don't have that much time. So I just had to break it down into something simple that I can get in my head. All right. So then the only issue then is what the amount of the repayment plan for this other amount is. That's the only thing I see that has to be dealt with. I think before we can deal with that, before we can deal with that, the landlord has to get out of their head that there's this pot of gold of money that was paid by Sarah, because that's not really the defendant's money. That's going to go back to Sarah. Crickets.
I heard you.
Okay. So why can't that be worked out?
There's a $900 difference. Their way of calculating it is incorrect.
Okay, there's
and
a nine.
Also
okay,
have to arrive at the amount.
Okay, people, let's do it this way because I'm going to have to walk this step by step. How much is owing on the repayment plan?
I'll tell you in a second.
I'm happy to go through the numbers. I know them quite well.
Oh, no, you're gonna go through them in a Michigan way. It's gonna be a lot of numbers. I just need a bottom line.
The bottom line on the repayment plan that we believe is incorrectly calculated is $3,669.
$3,669.
Yes.
Okay.
We believe the correct balance should be $2,733. It's about like Mr. Hu said, about a $936 difference.
Okay, you guys have baffled me again. At some point, folks, she signed, as I remember these agreements, she signed a promissory note to pay this money back.
That's correct.
This promissory note had a figure in it.
Yes.
Is that also correct?
Yes.
This promissory note was signed by all of the parties and may have indeed, as the parties went through it, did part of it, right?
Yes.
So now to counsel for the defendant, why am I going back recalculating numbers?
Your Honor, we certainly recognize that she did sign the document, but at that time she was unrepresented by counsel and is by no means an expert on how rent should be calculated. It was calculated based on a 52-week plan. She only received PUA for 39 weeks.
Counsel,
So
I get you, but the first hurdle that you got to get over is she signed the contract, maintained her tenancy. Why isn't she stuck with the number?
Your Honor, that's certainly one way of, explaining it. We don't think that would.
No, that was a question.
Okay, she was
Why
unrepresented at that
isn't she
time.
stuck with the number?
She was unrepresented at that time and did not have an opportunity to address the calculations and argue.
Okay, so here's the problem with that. Here's the problem with that argument. If she was unrepresented, that was of her own choice. As you can see, and how my courtroom has always run, if somebody wants to speak to an attorney, they get a chance to speak to an attorney. So I don't think she can come in, and I really believe that argument probably belongs more in a criminal context than it does a civil context. But even if I were to apply it, she could have had the advice of counsel to do her calculation, to do whatever's needed. Goodness knows we have a very active legal services community. So I'm not buying that one. I need a legal argument as to why she's not stuck with the number.
We believe that it would be unjust enrichment of the landlord. It would result in a windfall on the landlord because they miscalculated the payment and
which is the unjust enrichment, which if we're going to go to law school on this, which would be an equitable claim. And to the extent this court has a ruling on that, it also may be inequitable that the landlord has relied upon that number without objection. So bottom line, unless you show me something else, kind of give the party some guidance, I think she's stuck with the number. The issue then becomes, what's the reasonable way when all is said and done, how she can get it paid, not taking into account those SARA funds, how she can get it paid and still maintain her tenancy.
They've
If
offered
the amount of monthly payment has to be adjusted, I get it. We've been through a pandemic, and I think that would be an appropriate.
They've agreed to a payment of $25 a month, Your Honor, and the landlord would accept that.
The what?
$25 a month, which would take us probably 5 years to get it paid, but the landlord has agreed to accept that amount.
Your Honor, if I may just chime in for one moment, I understand that we're headed towards, that the client signed the contract, and I fully understand that. I just want Your Honor to be aware that at the time she signed that, there was not, as I understand it, an active court case. And so I don't think she actually had a chance to get representation. She was just called into the office and asked to sign this repayment plan. And so, to the extent that she would have been allowed to have counsel or ask someone for help, she felt that she was in a position, she was going to continue to live at the property at the time without representation, that she had to sign the contract. So again, I understand very much that Your Honor is saying that she did sign it, but she didn't have a chance to have representation or to have someone review the calculations. And with this particular landlord, there's been many calculations issues in the past. And so I think, for that reason as well, the representation in this particular instance might be of particular importance.
All right, I get that. I think if you guys want to show me something that the court on that basis could set aside a contract that she voluntarily entered into, then I'll take a look at it, but I don't. I mean, I think the problem is that that's then going to apply to all types of contracts that landlords are or that tenants and landlords are entering into. And the other reality of that is that the landlord, realistically, even for the 2,700, may not have had to enter into that payment agreement, which is a whole other issue of people being permitted to maintain their housing. So I would hate to get into a situation of the landlord then in the future not being able to rely upon it, then not doing it, and then that ends up with people who are homeless.
Understood. So, thank you, Your Honor.
Long range is how I guess I'm looking at it. If it were a number that were clearly, for whatever reason, unconscionable, not having any basis, not where there may be a dispute on calculation, then maybe that's a different issue, but that's not what it sounds like to me. So after all of that, the 25 a month, is that going to, in some sense, is that going to be agreeable to your client?
Your Honor, it's something we've discussed with our client. And just one final point I'd like to make on this issue is that
dear goodness. No, go ahead.
I think it's important. Otherwise, I wouldn't continue to add. But
where did you say you were from?
Boston.
Yeah. Okay. This is an Eastern thing. Go ahead.
Your Honor, we fully agree that the landlord, was being generous and allowing for her to sign a repayment plan at that time. But the reason that it got so far along in that it was 9 months worth of back rent that was not reported is because there was miscommunication and confusion around whether or not the pandemic unemployment assistance needed to be reported or not. There was actually conversations between our client and the management office in which they told her that it wasn't included at one point. And there are email documentations that we would be happy to provide to the court in December. There was still confusion around whether or not this needed to be included in her income calculations. So that's just one point I think that does.
Yeah. And I mean, I get that, but I don't think that misunderstanding is any different. If I were to put it on another level with individuals that were receiving that and how they were supposed to report it on their taxes. I mean, during that time, there were a lot of confusion about what people were supposed to do with this money, what that money would then be subject to. It certainly, just in the abstract, was a very confusing time for a lot of people.
And so that's exactly why we understand that there was a miscalculation, but what we're asking for is that Ms. Perryman just pays what is the correct calculation and the amount that she should owe based on 39 weeks, not 50.
Which is what the correct amount is what she agreed to.
Thank you, Judge.
That's where you're going to end up. Now, we can go through all of this, but I try to give people a hint as to where this court is headed. And then until such time as you show me something different, and that the court will be absolutely wrong in doing that, that's where we're ending up. I'm telling you that. So you can keep coming at me if you want, but it's not gonna do you much good.
So to sum up, the repayment plan is $25 a month, and will it start April 1st? I see nodding, but no voices.
Are you asking me to agree to that?
I think you already offered that yesterday. I just want you to confirm it on the record.
Yes, we can confirm that. That will work.
All right, so how do I get rid of this case and never have it called again?
I will enter.
I guess
will-
I should
I
have
can
put it.
prepare an order reconfirming the payment plan and the restarting of it as of April 1st.
I think what should also be included in any order is, so that we're clear on it, that the payment or the payment plan referred to, that Sarah has indicated that the funds cannot be used for that. The landlord is not entitled to any excess that may have been paid over, and that the tenant is responsible for working out arrangements with the Sarah program regarding those funds, so that everybody is clear on all.
Thank you, Your Honor. We would appreciate that.
Ms. McDivitt, would you like to propose the order that includes that language?
Sure.
Okay.
Okay, so do I mark this case settled, order to follow, or do I give you a new date to come back and see me since you're regulars?
I would give us a control date, Your Honor.
All right, then let's do this. I'll adjourn the matter out to April 8th. That's at least after the day, 2022, 9 a.m. All right.
Thank you very much, Ms. McDivitt. I'll look forward to the proposed order.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.